Good afternoon to everyone. This is Nia Singh, Principal Lawyer at Ma'at Legal Services in Toronto, Canada. And today is a press release on the Comprehensive Legal Inquiry into the death and killing of Jamal Francique. Counsel Nia Singh and Howard Morton and the rest of the staff at Ma'at Legal have prepared a comprehensive legal inquiry into the killing of Jamal Francique, precisely due to the fact that the SIU has cleared the officers and any criminal liability stemming from a shooting on January 7th, 2020. This comprehensive legal inquiry is the first of its kind. It is a response to the SIU report and a call on behalf of many affected communities and members of police violence for a reopening of this investigation, hopefully to set a precedent to reopen other investigations that are suspect. The purpose of the comprehensive legal inquiry, also referred to as an independent legal inquiry, is over the past 30 years, the SIU has been mandated to independently investigate instances of police interactions with the public that lead to death, serious injury, or sexual assault. Over a period spanning almost 4.5 years, from 2017 to April 2021, there have been 36 SIU investigations pertaining to firearm deaths. 8 of those investigations are ongoing, but of the 28 that have been completed, the SIU did not issue a single charge against any police officers. That 0% charge rate casts doubt on the notion that the SIU conducts fair and objective investigations when civilians are shot dead by the police. This CLI will examine the report put forth by the SIU in case 20-OFD-005, focusing on the information presented, the nature and quality of the investigation, the legislation governing the SIU, and the legal reasoning behind the decision of the SIU director not to charge the officers involved. Contained in the report will examine the information presented, the circumstances surrounding the incident on January 7, 2020, the SIU investigation, the quality and thoroughness of the investigation, the procedure and regulations, the evidence, the inaccuracies and discrepancies in the report, and unanswered questions. And finally, the report looks at the analysis of the director's decision with an examination of possible criminal code charges, how the arrest was planned, and the overall analysis of the director's written decision. To point out, there are many discrepancies in this report, in the initial report from the SIU. Those discrepancies lead one to believe that if the SIU could not produce an accurate, reliable report, what information is the director receiving, and how does that affect his decision? The SIU investigation contained many flaws, many holes. One of the most significant flaws and omissions is the analysis of the director into the planning and execution of the events that led to Jamal Francique's death. Jamal Francique was under investigation for 3 days for drug activity, and that investigation turned up 0 results. At the end of the investigation, the drug squad from Peel Police decided to orchestrate a high-risk takedown of Jamal Francique on the day of January 7th, 2020. This ill-fated takedown was done at nighttime with 6 undercover officers in plain clothes and unmarked vehicles. And in this investigation, the officers observed Mr. Francique walk from his home approximately 200 meters for about 2 minutes to his car. The plan was supposed to block Mr. Francique in his car and make an arrest. However, the officer arrived late and allowed a myriad of events to take place, putting the public and Jamal's life in jeopardy. And the unfortunate result was Jamal lost his life due to the incompetence of the officers and the ill-fated plan. Evidentiary record is incomplete. 4 shots were fired from the subject officer's firearm, and in the report, only 3 of those bullets are accounted for in the analysis. The report breaks down the assumptions made by the SIU as the SIU could not get the Center for Forensic Science, CFS, to complete a ballistics report, and this is a major flaw in this investigation. When looking at the bullet impacts, we understand that the SIU claims one hit the roof and entered from the driver's side towards the passenger side at a slight downward angle. The second bullet, middle right of the front windshield, driver's side towards passenger side at a slight downward angle. And then three right area of the windshield with a slight passenger side to driver's side direction at a slight downward angle. Never is the fourth bullet mentioned in that aspect. And it is our evidence that that fourth bullet hit Mr. Francique in the back of his head and ended up lodging in the right temple of Mr. Francique. There is no explanation of how that bullet entered and what are the possibilities. Our investigation has revealed that there is evidence, which is contained in the report on page 15, that there is a graze on the back driver's window that may indicate a bullet had been fired and nicked that portion. Looking at that at this stage would demonstrate that potentially that bullet is the bullet that entered Jamal Francique, the left side of the back of his head. What is contradictory in the report is the subject officer in his interview with the director states that he fired 4 shots in rapid succession at the front of the vehicle. If that were the case, how did a bullet end up in the back of Jamal Francique's head? Furthermore, there is evidence in the Comprehensive Legal Inquiry that there may be some destruction of evidence as indicated when the TAC officers attended the scene and ended up smashing the front windows of the vehicle. There's no indication in the SIU report how many windows of the vehicle were broken by the SIU, by the impact of vehicles, or by firearm and gunshots. This omission is suspect, and it's definitely something worth looking into. There's also an aspect of a firearm allegedly found on Mr. Francique, which is contrary to the initial reports, which do not mention a firearm at all. Over a year later was the first time any members of the family or council were made aware that a firearm was allegedly found at the scene. And the SIU report itself contradicts itself when it states, first of all, that the firearm was found in the waistband of Jamal Francique. And then later in the report says the firearm was found in a black satchel. What is interesting is that upon recovery of Jamal's property, majority of his clothing was blood-soaked, yet the guest's satchel, where the firearm was found, has no evidence of blood at all. There are numerous other discrepancies in the report, such as the report listing 7:44 p.m. as the time of the shooting, and then contradictory in the report listing it as 5:45 as the time of the shooting. Page 4 of the report, the SIU report, states that Peel Regional Police Street Crime Unit were intending to arrest Jamal for breach-related offenses. Yet, with respect to drug investigation, yet later in the report says the decision was made to arrest him in violation of his bail. Also, there's a description of a blue Acura and a black Acura. The report also states that officers, when they approached the vehicle, Jamal drove at them. Yet it is very clear in the report that there was an orchestrated series of events, such as the reversing of a vehicle, the blocking in by police vehicles, unmarked police vehicles, and then the subsequent attempt of Mr. Francique to drive around one of the officers, which led to the fated shooting. The circumstances of the cars blocking in Mr. Francique is somewhat confusing, and this is another reason why a reopening of this SIU investigation is a must. It is a must to maintain confidence in the justice system, confidence in policing, and confidence in the oversight of the SIU. Another discrepancy in the report is on page 4 states Jamal was shot in the face, and then on page 11 states Jamal was shot in the back of his head. These discrepancies, inaccuracies are of serious concern. There are a series of unanswered questions that are located in the report, stating, it would appear from the report's incident narrative that members of the PRP Vice Narcotics Street Level Organized Crime Unit gathered to discuss the ongoing surveillance of Mr. Francique. They were in possession of some unconfirmed drug trafficking and firearm information and had reasonable grounds that he had breached his bail, which constituted a relatively minor hybrid criminal offense. A decision was made to orchestrate a takedown arrest of Jamal for this offense. Keeping in mind this takedown arrest was totally unnecessary on behalf of the drug unit. Uniformed officers at any time could have been sent to Mr. Francique's home to facilitate an arrest. A call could have been made to any of his sureties, and Mr. Francique could have been stopped on his way to his vehicle and arrested for the breach-related offense instead of allowing him to enter his vehicle, knowing that the other officer was not present, and allow a very dangerous circumstance to unfold. Questions are as followed. What options were considered as to how and when to make the arrest? Was attending at the Francique household where he lived with his mother and stepfather the most viable option, and if so, why? Why was it known whether his parents or any other persons were home at the time of the plan? Did the prior surveillance suggest some other place or means of making the arrest? Was any consideration given to obtaining a search warrant or tele-warrant for the house and Jamal's car if needed? Did the unconfirmed information disclose where drugs or firearms could be found, in the car or the house or elsewhere? Were street maps or diagrams or photos of the Francique household considered during the planning decisions? Was there ongoing surveillance of Mr. Francique at the time of the planning? If so, what did it reveal? And why was the decision made to effect the arrest of Mr. Francique using only plainclothes officers and unmarked vehicles when uniformed officers could have been assigned to this task, especially since the drug investigation yielded 0 results? The analysis of the director's decision is probably the most important part of this comprehensive legal inquiry, as it demonstrates that a director's decision must be made on reliable and credible evidence, which is why charges being laid would facilitate that process. On page 10 of the report in paragraph 2 under this heading, the director makes specific reference to his decision being based on the record developed by the SIU, which, although necessarily so, is a rather strange way of putting it and leads us back to an assessment of the thoroughness and quality of the investigation itself. A director's report should at least make reference to all of the evidence gathered by the investigators and which is relevant to the director's assessment and decision. The fact that the report does not refer to all of the unanswered questions and issues earlier in our response leads only to 2 possible conclusions. The investigation was so inadequate that it did not investigate the matters we raised above, which in our view are crucial to determining if there are reasonable grounds to lay criminal charges in the case. And 2, if some of the issues and unanswered questions were investigated, the director's failure to refer to them can only lead to a lack of trust and confidence in the ability and adequacy of the SIU, both in terms of its investigators and its directors. Listed in the Comprehensive Legal Inquiry are possible criminal code charges, which are as follows. Section 219, Criminal Code, criminal negligence. Everyone is criminally negligent who, in doing anything or in omitting anything to do that it is his duty to do, shows wanton or reckless disregard for the lives or safety of other persons. For the purposes of this section, duty means a duty imposed by law. Next, causing death by criminal negligence, Section 220 of the Criminal Code. Every person who by criminal negligence causes death to another person is guilty of an indictable offense and liable. A, where a firearm is used in the commission of the offense, to imprisonment for life and to a minimum punishment of imprisonment by a term of 4 years. And B, in any other case, to imprisonment for life. At page 14 of the report, the SIU report, the director states, liability in relation to both criminal negligence causing death, bodily harm, crimes is predicated in past on conduct that amounts to a marked and substantial departure from the duty of care that a reasonable person would have exercised in the circumstances. One can only conclude that the director's failure to apply the test to the level of care that a reasonable police officer would do is an important circumstance in such cases, and that the person is a police officer, fully trained in such situations, armed and exercising powers unique to the police. The director goes on to state, though these are legitimate questions regarding the nature of the police conduct leading up to the shooting, I am not satisfied on reasonable grounds that any indiscretions, if they be such, deviated markedly and substantially from a reasonable level of care. The Ma'at legal team disagrees. We find it remarkable that the director would categorize the various derelict and inadvertent decisions made from the initial planning, strategy, and on-scene decisions, including shooting at a speeding vehicle, as possibly indiscretions. The entire series of events leading up to the killing of Mr. Francique were not merely possible indiscretions, but were, in our view, evidence on which to base an honest belief on reasonable grounds that criminal negligence causing death has been committed. We appreciate that looking at the entire disarrayed and botched events leading up to Mr. Francique's death would cause the director some difficulty in designating who would be subject officers and witness officers, which has often caused public confusion and mistrust. But such decisions cannot be an excuse for not conducting a capable investigation and decision as to criminal charges. In addition to the omissions, unanswered questions, and issues set out above, 4 major factors referable to criminal negligence causing death were never fully addressed by the director, or apparently didn't deserve the investigator's attention. 1. Whether any of the officers involved throughout the misadventure adhered to established police training at Peel Regional Police, in particular training with respect to A. Surveillance, B. Appropriate methodology in planning and execution of takedown arrests, C. Search warrants and telewarrants, D. Preventing vehicle movement, E. A means of retreat as opposed to discharging firearm at an accelerating motor vehicle, F. Ensuring expeditious medical assistance. 2. More than 4 decades ago, many police departments, state legislators, and federal guidelines in the USA prohibit police officers shooting at a moving vehicle. Police tactics experts have set out the reasons for such prohibition, which include A. Shooting at a 3,000 to 4,000 pound vehicle is an ineffective way to stop it. Not only is the officer likely to miss it, but may actually hit someone else by ricochet. B. If the officer is able to shoot the driver, the result may be that the accelerator may accidentally be floored by the driver, causing the vehicle to continue acceleration for some length of time, resulting in great danger to the public. C. If the officer shoots the driver might accidentally or intentionally drive right at the shooter. D. If the officer is successful at shooting the driver, you have an uncontrolled vehicle. E. The risk-reward balance clearly favors not shooting. In this case, Mr. Francique was allegedly fleeing from arrest for breaching a house arrest condition. There is nothing to suggest that he could not have been arrested later that evening or another time in the near future. They knew who he was, they had his address, and they watched him leave his home and return. There is no discussion in the director's report as to the location of the forced shell casing and its meaning in pinpointing the precise position that the subject officer was in when he fired at least one of the 4 shots. The director reports that an accurate trajectory reconstruction could not be conducted by the CFS, yet the director did not seek a second opinion from other experts in the field. Trajectory analysis is often conclusive with respect to where the subject officer was when he fired each of the 4 shots. Why was CFS unable to do a more thorough testing? Other potential charges are murder and manslaughter. And in the defense under Section 34.1, the threat of use of force that an officer is able to rely on, there are many factors that have not been considered in this report that may not relieve officers of that protection. Another charge is duties tending to the preservation of life under Section 215 of the Criminal Code. Everyone is under a legal duty as a parent, foster parent, guardian, or head of a family to provide necessaries of life for a child under the age of 16 years. B, to provide necessaries of life to their spouse or common law partner. And C, to provide necessaries of life to a person under his charge if that person is 1, unable by reason of detention, age, illness, mental disorder, or other cause to withdraw itself from that charge, and 2, is unable to provide himself with necessaries of life. The reason why the necessaries of life is of such importance in this case is that Mr. Francique lay bleeding out in the vehicle for over 25 minutes while officers yelled commands to show your hands and step out of the vehicle. Instead of officers ensuring that Mr. Francique did not require medical attention or having TAC officers approach the vehicle at an earlier stage, they've allowed Mr. Francique to be in a much worse condition than he was, which is in essence a failure to provide necessaries of life. There are many other aspects of this case that require scrutiny, require public scrutiny, legal scrutiny, and scrutiny from our provincial government, who is tasked with setting out the mandate legislation for the SIU and civilian oversight. Justice Tulloch in his report years ago has outlined many recommendations for the SIU. I implore that these recommendations be taken seriously and that a reopening of this investigation take place immediately so that the public can receive answers and the SIU can make the correct decision based on all of the evidence available. At this time, I'll take questions on behalf of the media. The report has been sent out. It can also be located at maatlegal.ca under the media page, and the report is there for everyone to view. So at this time, I will open up to questions from the floor.
Jason Miller here from the Toronto Star. Can you hear me?
Yes, I can. Thank you, Jason.
Thanks, Nia. Consider that there's pretty much no precedence for this. What are you basing this unprecedented filing upon? I mean, you're trying to break ground here, I suppose, is what's happening.
We have broken ground, Jason. This is necessary because the legislation does not leave any opening for an appeal of an SIU decision nor an inquiry. And without waiting for the government to make up their mind and make legislation, counsel on behalf of the family felt it was important that this report be offered and that this report be something standard going forward for any decisions that are made by the SIU, especially those that are based on shaky grounds. There are many in the past that are warranted a comprehensive legal inquiry.
And just a quick follow-up to that, because I know I have other colleagues on here. Since there's no precedence and you say you're breaking ground, what's the levers or the channels then for this to go through? In many legal avenues, you have different boards or tribunals that you would file this to. Does this strictly go to the desk of the Attorney General, or what's the path here? What's kind of the 1, 2, 3 steps for this process that you're starting here?
Well, we're definitely relying on the Attorney General to review this report and actually analyze it and say, yes, based on the evidence provided here, we should reopen this investigation. Set aside from that, there are possible avenues through divisional court and through an appeal, a public appeal. I would say that the public has probably the most power in the sense if they are to write into the directors, write into the agencies and state they want a public inquiry on this, then it should be done and it should be reopened. And I think there's sufficient evidence in this report to show why that's necessary. And next question from anyone from the floor?
Howard, I see you're here. We talked recently about another case, involving the H.S. Chaudhry, different kind of evidence or material in that one, but you're involved here. What's kind of your involvement? Are you supporting counsel? Are you, as a former director of the SIU, what role do you play as a part of this?
I'm simply, Jason, assisting Mr. Singh in terms of trying to get this investigation completely revisited by the SIU, and if they fail to do it, to take all other available remedies to try and bring some sense of justice, not just to the family of the deceased, but their community and the public at large. I mean, I know, Jason, you've always been interested in how do you measure the quality of the SIU, and we've talked about that before. And I know some people use numbers, only 3 charges out of 27 or 110. I've never felt that that is a measure by which to measure the quality of the SIU. You measure the quality of the SIU in 2 stages. Number 1, how good was the investigation? And number 2, did the director accurately apply the law to the findings of the investigators? In this particular case, Jason, I know you haven't had much time to read the report or our report, but I mean, this was totally and completely a botched up attempt to take a takedown arrest. If Jimmy Breslin were alive today, and many of you may be too young to know who Jimmy Breslin is, I'm sure he would have written a book, The Gang That Couldn't Carry Out an Arrest, or Can Anybody Here Investigate the Death of a Member of the Public in an Interaction with the Police. I mean, this entire attempt to arrest Mr. Francique was botched from the outset, and yet the director does not examine the planning, what was the existing significance of facts that they knew before they decided on a plan. When they got to the scene, did they make any adaptations to the plan? Who was in charge? Was there a lead officer? And so on and so forth. So that my hope, in addition to helping Mr. Singh, is that by some measure we will have accountability of the SIU. Every police service in Canada has several layers of independent review and accountability. The SIU is one, the police service boards, city council, the OIRPD, and so on and so forth. There is no accountability vehicle for the SIU, and so there is no way of the public measuring whether it does good investigations and whether the director correctly applies the law. And without that, I mean, the public at large doesn't trust any of us in the justice system, not lawyers, not judges, not courts, and not jails. So the SIU suffers a little bit from that general distrust, but it's creating a distrust of its own when it puts out an investigation and a report that is just so deficient and so misguided in coming to the conclusions it does.
Nia, I see there's not much time as the meeting is notifying me under 3 minutes. So as you said, just to be clear, you found no other example in the history of the SIU of any attempt to do something like this. Am I clear on that? Nia?
Yes, Howard can probably speak to that more, but in my lifetime, I was alive when the SIU was created, and I've been paying close attention. I've never seen a contesting of a report or an appeal or a response to an SIU report done in this fashion. And we intend for it to have meaning and break ground, because it is about time that the SIU is held accountable for them supposedly holding police accountable.
You say this is interim on the label, and just jump in quickly. When can we anticipate this will land on the Attorney General's desk?
Today.
Okay.
This interim report will end on the Attorney General's desk today, and then subject to all the information that we obtain throughout our investigation, we expect to get everything the SIU had to work with and create our own conclusion in a final report. And I think that's only fair and necessary in order for a fair and transparent investigation to be done and considered. Okay, thank you everyone for attending. And if you need a copy of the report, please email us at media@maatlegal.ca. Thank you.